Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, CEO and Managing Partner of Cordell and Cordell. And as you know, every week we've been bringing to you the latest information as it relates to COVID-19 and its effect on all things in family law. And today is no different. We want to bring to you something a little bit, change the pace up and talk about kind of the reopening of the states around the country and upcoming summer schedules, and talk a little bit about how that's affecting guys and how they should be preparing for that, and really the differences around the country. And so again, we'll bring you a group of panelists of Cordell and Cordell attorneys from around the country to bring you what's going on the ground, including an update on what's happening in their court system as well. And as you know, Cordell and Cordell is the largest law firm of its kind, representing guys before, during, and after divorce for the last 30 years. And here we're celebrating our 30th anniversary this year. Keep in mind, stick around for the lightning round in the second half of our virtual town hall. You'll have an opportunity to ask questions live and submit that via the Q&A section where you can log in and ask it live of our panel, and we'll provide answers to you. If you prefer not to answer it live, you can submit that via the chat box. I'll go ahead and read that question to our panel and get you answers as well. But also you can tune in to the daily podcast where we'll address specific issues facing guys. And once each week, we'll address questions submitted at coronavirus.divorce@cordelllaw.com, or any questions that we get to today or that we can't get to today. We'll address those in our daily podcast once each week, where we just talk about specific issues for guys for about 15 to 20 minutes. Keep in mind, as we talk about each week, that this is not to establish an attorney-client relationship. It is not to be taken as legal advice. I'm only licensed in Missouri, Illinois, and Georgia, and our group of panel also has limitations on their licensure. But more importantly, the facts and circumstances in your case will certainly differ and will likely lead to potentially different discussion points and probably different answers that we addressed today. So again, stick around for the lightning round. Submit your questions right now via the Q&A. If you want to read those live, give us your first name and just the state that you reside in. We'll keep everything private, so no last names, please. And if you want me to read your questions, submit those now so you can get in the queue and the chat box, and we'll get to those in the second half. So let's introduce to you the group of Cordell and Cordell attorneys that we have joining us today from around the country. Let's start out in Minnesota. Melissa Taylor, welcome.
Thanks, Scott. My name is Melissa Taylor. I'm a lead litigator in Edina, Minnesota. I've been practicing for about 7 years, almost exclusively in the area of family law, and I've been with the firm for just about 4 years. Thanks for having me today.
Thanks, Melissa. Let's go to Lincoln, Nebraska. Meghan McDowell, welcome.
Thanks, Scott. I appreciate you having me on here. Like you said, I'm Meghan McDowell. I practice in Lincoln, Nebraska. I've been practicing for about 5 years exclusively in family law, and I've been with Cordell and Cordell for about a year now. And I'm actually licensed to practice in Nebraska as well as the Ponca Tribal Court.
Great. So as we try to bring you all around the country, so we have offices around in 37 states. Let's go out to California. Laura Matzi, welcome.
Thanks, Scott. My name is Laura Matzi. I am an attorney based out of our Foster City office here in California. I am licensed both in California and in Illinois. I've been practicing for about 5 years, primarily in family law, and this is about my 3rd year with Cordell.
Thanks, Laura. Let's go to Georgia down south. Nick Grenade, welcome.
Hi, I'm Nick Grenade. I'm a litigation manager over here in the Fayetteville, Georgia office. I'm licensed here in Georgia. I've been practicing for about 10 years, 5 years with Cordell and Cordell.
Thanks, Nick. And joining us from Indianapolis, Indiana, Rex Padgett. Welcome, Rex.
Thank you, Scott. Again, Rex Padgett with the Indianapolis office. I've been practicing family law primarily for about 7 years, and then with Cordell and Cordell for 3 years, and appreciate the opportunity. Look forward to the discussion.
Thanks. And rounding out our panel for today is Christopher Kennedy in our Scottsdale, Arizona office. Welcome, Christopher.
Thanks, Scott. I'm Christopher Kennedy. I work in Scottsdale, Arizona. I'm licensed here in Arizona and a litigation attorney with Cordell and Cordell for approximately 3 years now.
Thanks, Christopher. Now keep in mind, in the second half of our virtual town hall, again, you have an opportunity to ask questions live and get our answers from our panel. You can do that via Q&A. If you want me to read your questions and I'll get an answer for you, you can do that via the chat box. Again, first name and state, so we can make sure we can try to distribute it to someone if we have a panel member in your state, get you kind of the most up-to-date information as possible. Really, this has established some talking points for you to seek out a consultation with an attorney. And obviously, we're available at 866-DADS-LAW, 866-DADS-LAW, or you can find us on the web at CordellCordell.com. We're available for in-person, we're available, and we're appropriate based on health and safety of you and our employees, or telephone or virtual as well. So again, 866-DADS-LAW. So as we start out each Thursday, after we introduce our panel, we talk a lot about what's in the news. In the last few weeks, we've talked about the celebrity divorces, and both before, during, and after, and what's going on. But more appropriately today, as we've seen most, if not nearly all of the country starting to open up in some way or the other, we start to see some courts beginning to ease the restrictions that they have. And we'll turn to an article in the Brooklyn Eagle to start us out, and we'll turn to Laura out in California. And really what we want to know, and guys have tried to really grasp the situation on the ground with regards to the court system and what they can do. So maybe to start us off, Laura, tell us and update everyone watching what's going on in California. What's the status of the court system? You know, can they file? Is it open? What's going on?
Sure, Scott. The state of California has left it up to the individual counties to kind of decide how they're going to handle reopening. And like the article, the attorneys there, we're all concerned about the backlog that this is going to create. Different counties here have created different ways of handling the backlog. We have seen some counties here easing their restrictions on filing, whereas before we had only emergency filings or no filings at all. Now we do have the ability to file increased number of motions, including non-emergency matters. If you are still in a county in California that is only accepting emergency filings, you can provide notice to the other party that you intend to file a modification, which can be so important for support, especially for the matter of retroactivity.
Yeah, that's a huge point, Laura. I know we've talked a lot about that. We talked about it with Rosario in San Diego office about at one point we weren't certain if we could e-file. We were filing via FedEx and having a return to the court system, but we really felt, as you suggest, sending the pleadings anyway, serving the opposing party, putting them on notice. And that is a huge point for guys right now to write it down, have that conversation with an attorney, because retroactivity is in this era when we have now, and every Thursday we have unemployment numbers that come out, nearly another 3 million are added to the rolls. We're now at about 39 million unemployed. We figure half of that, representing guys, another half, probably 10 million, are guys questioning how they're going to make their next payment, how they're going to not only support themselves, but their child support. So in terms of e-filing, are you having some success in even doing some hearings at all with the court system, whether it be virtual or otherwise?
Yes, there are several counties now that are accepting e-filing, and certain counties are now opening up to fax and mail filing as well. I have been lucky enough to experience a few counties here who are starting to introduce virtual video hearings. These can create their own issues. I think that they're very appropriate for brief hearings, status conferences. They can help the court move the calendar forward, which is so important as we move to reopen.
Yeah, it's huge. I mean, not only guys, as you watch and you listen to the daily podcast, they want to know what to expect. And we're learning as they are. In fact, I know each county and state, they're having conferences with the attorneys to try to update them on what's going on and the plans to move forward. And let me turn down to you, Megan, down in Lincoln. And really, have you had an opportunity, are we seeing Zoom, the use of Zoom for settlement conferences, status hearings, emergency motions? Are you seeing something like that in Nebraska?
Yeah, Scott, we actually have been doing Zoom hearings or WebEx hearings here since right after the schools closed in the middle of March. And I've seen a lot of really good success for certain kinds of hearings. We never had a stall out of being unable to file. So we've been able to file, we've been able to have temporary hearings. When we get into the issue of like a trial with evidence and a lot of witnesses, that seems to be where we have the biggest kind of issue with trying to figure out, can this be on Zoom or do we need to push it out a little bit further so that we can have that in-person hearing instead? But we've seen a lot of really good luck so far. At least I personally have seen really good luck with those Zoom hearings.
There's so many questions, and we'll talk a little bit about use of Zoom a little bit later on because it's so important. But Megan, I guess the question is rather than just jumping into technology that perhaps this is the first time for all of us, and I have kids and they're teaching me how to use Zoom at its best. And I imagine guys are kind of limping along the way, and some lawyers across the country are the same way. But don't you think guys should be one right now? The first thing that they're writing down as notes as they're watching us is get with your lawyer, prepare for the next Zoom hearing, have a practice run, kind of just get used to what's going to happen. So it doesn't seem like there's a lot of hiccups. It seems as smooth as possible, don't you think?
Yeah, I absolutely agree. I know when I've met with my clients and helped to prepare them for those hearings, we have talked about some of those potential issues and what we can do to prevent anything on our end. Sometimes there are some inadvertent technology issues, but we try and do what we can to minimize those, at least from our end.
Well, Nick, let me turn to, there was a Kentucky article in the Courier that really outlined, it really not state specific in terms of something that we're not seeing across the country, but some significant restrictions that are being placed on courts in Kentucky particularly. But, start out, what's going on in Georgia? What's happened with the status of the courts there? And we'll talk a little bit about that Kentucky article.
Sure. Thanks, Scott. Great question. I looked over the article, and it's different than how things are being done in Georgia right now. Whereas it looks like in Kentucky, from the Supreme Court of Kentucky, they're telling the courts to reopen as of January 1st, and then they're spelling out restrictions within that judicial order. Here in Georgia, it's a bit different. The Georgia Supreme Court has issued the judicial emergency extension, allowing each local court system to kind of make their own decision about how comfortable they are reopening for live hearings. And in the meantime, really emphasizing the use of video conferencing for hearings and so forth. There's also the issue of deadlines. We have been able to electronically file kind of throughout this. I guess we've been kind of lucky here in Georgia in that respect, but any litigation deadlines that would have come about, for discovery or for any kind of service have all been suspended until just recently. And again, though, the Supreme Court has said, we're going to leave it to each judge to make decisions on particular cases as to whether they're going to lift those suspensions or continue to allow them to be stayed.
And I think you make an important point about county-specific guidelines, because we watch national news, we hear closed, and closed, or the courts are closed, or things are stacking up, and it really is. I mean, whether you're in North Carolina or you're in Florida or you go all the way down to California, you got to really figure out what's going on in your particular county, because you could be 45 minutes away and they're wide open, just like we are in Missouri. I could probably travel in an hour and they're having in-person hearings with social distancing rules and mask rules, but you may stay here where I'm in St. Louis County. The courts are closed in terms of in-person hearings unless absolutely necessary. And I know there was a mention in the article about jury trials. And obviously, for most guys here, for 48 states, they don't have to worry about a jury trial except for Georgia and Texas, I believe. You have the ability to get a jury trial. So what's going on with jury trials in Georgia?
That's a great point, Scott. There is a distinction that the Georgia Supreme Court has made, and they are not allowing jury trials to move forward until further word from the court. So there's a distinction made between, civil hearings in front of the judge as opposed to a full-on jury trial. I also would just piggyback on what you said a little while ago, that even down the road, I'm in Fayette County, Georgia, down the road in Coweta, they're opening back up in state court over there, which is a misdemeanor prosecution court. So not exactly domestic, but it just shows that difference in how different courts, different judges are handling their courthouses. I will say, I've been across the state of Georgia virtually this week. I practiced up in North Georgia on Monday, and then I was down in South Georgia virtually. And so that seems to be working, but again, being a distinction between a final hearing with perhaps complex evidentiary issues and an interlocutory or an emergency hearing that would be a lot more brief and probably less evidentiary issues.
Yeah. Well, let me turn to the Spokesman article. It really talked about, again, delays and the use of Zoom technology. I'm going to turn to you, Rex, up in Indiana. Let's let everyone know what's going on with the court system in Indiana right now as we've talked and started each one. What's happening there?
Great question, Scott. And our courts, very similar to what Nick was talking about, we've always had the ability to e-file, so there's no shutdowns there. However, we are seeing some delays in getting some of the hearings final hearings and things like that. I actually tracked one case in particular. It's a grandparents' rights case, and that one was set for a hearing. It was set for 4 months from now. So that doesn't seem very timely. And so I anticipate some of our fathers experiencing similar things like that. For the most part, courts are doing individual. The Supreme Court has granted each individual court or county the ability to open and reopen as they want, and based on the state guidance. Marion County, where our Indianapolis office is, they're not going to have any in-person court until June 15th at the minimum, and they're encouraging actually courts to continue with the remote hearings. I was on a WebEx versus Zoom hearing last week, so they are using different platforms as well. And as everybody's already talked about, some of the technology challenges, internet connections, introducing evidence, speaking to your client during your hearings is all difficulties. And that's exactly what I did prior to, is I set up a WebEx meeting with my client so that we could experience some of those challenges and share information, do a chat, because you can privately chat on a lot of these things, or enter a different room, so to speak, so that it's not shared with everybody. So we did a rehearsal ahead of time.
Yeah, and I think it's important to really, as we think about the effects of coronavirus, kind of indirectly shutting the doors and maybe delaying things, and the wheels of justice have kind of come to a grinding halt. It just means when we come out of it and you look through these articles, especially the one we talk about in Brooklyn, everything's going to stack up, and we just don't know what the timing's going to be. But what it does mean, and as you suggest, Rex, that some judges are preferring to just continue to move forward. Pick Hendricks County, right? They're a little bit open. They're limiting some head counts, but their doors are open a little bit.
Correct. Yes. Again, they started opening up around May 11th for in-person hearings. Your typical hearings, what I would consider provisional, final hearings, child modifications, and those are going to continue on a limited basis. 15 people allowed in the courtroom at one time, and so that includes the court staff. Masks aren't required, however, they are encouraged. And so again, it does limit and have some effects on who's in the courtroom with you, how much stuff you can bring at the counsel table. It's typically yourself, the attorney, and your client, and they are allowing one other staff member of the attorney to be there as well. So when you think about the context, it's definitely something different, but absolutely, as you indicated, I read an article actually just last night from a judge's perspective. They did a poll on judges, and some judges are preferring to do these remote hearings, much like they do in a criminal court, where they do their initial hearings or pleadings via telephonic or video. And so they want to continue those, and Zoom seems to be leading the way in regards to the preference for the judges.
Yeah, I agree. I think the technology, whether it is WebEx or Zoom, I do expect that that'll continue for some time. And I think it's incumbent upon guys watching right now, but more importantly, lawyers, is to figure out how do we best use the technology to not just wait until the doors open, but to further the case now. And for guys watching, that's the conversation you want to have with your lawyer, is first, hey, what's going on? What can I do? And now, how can I do it? And what must I do to move my case forward? We'll talk a little bit about that a little bit later, because the whole impact of us reopening, we're on the precipice of summer. We have some cities and counties and states that go year-round school. We want to talk a little bit about that as well. But I want to turn to Christopher and talk about the notion, this ABC 7 Chicago article that talked about virtual divorces. And I guess the question for you, Christopher, is, are there advantages to using the Zoom technology or WebEx, right now? Is there an advantage to it? And maybe is there some disadvantages? You can go through both.
Sure, Scott. Yeah, there certainly are some advantages to virtual hearings. In fact, here in Arizona, it's very typical, even before COVID, that status conferences and shorter hearings were held telephonically. Certainly, it's more comfortable for the parties to be able to appear remotely. They don't have to travel to the courthouse. They don't have to go through security. It allows social distancing to appear virtually, but I would say some of the disadvantages of appearing virtually is it requires a significant amount of preparation. If you're organized, everyone's got to have a copy of the exhibits. You need to practice with clients on how to get those exhibits into evidence to make sure everyone is on the same page remotely. conducting examination of witnesses can be a little difficult virtually. And certainly there's something to be said for being physically present in the courtroom. Parties tend to take it more seriously if they're required to, show up physically in front of a judge. Attorneys are certainly comfortable. We've been in courtrooms for most of our careers, and what we rely on sometimes is being able to read the reactions of the parties, the witnesses, interact with the judge. Those can all be helpful for cases to be there physically.
Yeah, I think it's important. And as we get better using it, I actually think that we may become more efficient in the system by using the technology, because a lot of times wasted. And I know we all do it. There's delays getting back to the chambers, talking to the judge, having a conversation, delays back and forth. I just see that once we get used to this, we can really use it to our advantage. And I think the court system may move a little bit smoother to do the non-essential things, like the settlement conferences, and as you suggest. Let me turn to Melissa up in Minnesota. We're talking about this virtual divorcing, and that tends to be this trending couple of words. It really just means that you're not in the court system anymore. You're not in the physical court building getting divorced. But first, let's talk about the status of courts in Minnesota, and particularly in the Minneapolis, Edina area. What's going on?
Sure. So like others have said, it tends to be county specific for the most part. We've been seeing counties with a huge backlog, and they're trying to address that, as well as ongoing cases. There's one specific county who's saying, we're going to handle all the hearings that have been backlogged, just the temporary hearings, the motion hearings, those types of things. And then we're going to handle all the trials toward the end of the year. We've got other counties that are scheduling those more routine type of hearings right away. I got notice for a hearing that was a week later. So it kind of depends on the county and probably what their backlog looks like, what their incoming cases look like. We've been a state that it's based on our service more so than our filing deadlines. And so we've been able to file the entire time. And I've even been encouraging clients to do that, so that once we do start getting hearing notices, they're in line to get one next.
Mm-hmm. There's also privacy concerns. We know we're always worried about the privacy of information. And now that we're doing it virtual, and you can be worried about virtual transactions with a credit card, and we seem to be more concerned about that and not realizing what's happening here. But how do we get through these privacy concerns, and what are the challenges, especially with the attorney-client relationship when you're in different remote locations in the middle of a Zoom or a WebEx hearing? What's going on with that?
Sure. In mediations, I think it's a little bit easier because you have the ability to do the breakout rooms. Sometimes you're even probably more private than if you're a thin wall away from the other party. But in court hearings, I'm used to having a party next to me with a notepad and being able to take notes from my client as necessary during a hearing. And when we're doing the Zoom hearings, you're in two different locations. It's really difficult to do that. So there is a chat function, but a lot of times everybody can see those too. So I've been talking to clients about, text me if there's a question that you have, if there's something that you really need to make sure that we tell the judge. But at the same time, there's a caveat with that. You want to make sure that the judge doesn't think that your client is just messing around on their phone and playing on their phone during a really important court hearing. So you want to make sure that you let the court know, hey, here's how I'm communicating with my client if there are any issues that arise.
Yeah, and I think, as we continue to roll out and open up across the country, a guy should be thinking about, maybe it's possible to maintain social distancing, wear appropriate masks if necessary and required, and have you and the attorney in the same room, but still having them, the minimum 6 feet away. You could go on mute and have that conversation. I think that when we talk about this, everyone thinks, well, we have to be in 3 separate locations. So it's a conversation to ask. And I think this whole Zoom technology, Melissa, is important, especially when we talk about distance counties, things that are maybe an hour away. It actually makes it more affordable for clients because we're not in the car driving to the courthouse, right?
Yeah, absolutely. I have hearings that are all over the state of Minnesota. You could have a hearing that's a couple hours away in Rochester, and instead of having to drive there, you can appear by Zoom. Courts are getting so much more used to that, where some of the outstate counties may not have even wanted you to do a telephone hearing before. But now with everybody getting used to this new technology and getting comfortable with it, including the courts, they're starting to open up those possibilities. So I don't think it's, at least in Minnesota, I think it's an option for us to make that request of a judge if we're located in Edina near the Minneapolis area and we have a hearing that's a couple hours away.
Yeah, if we can take anything away that's a positive from COVID-19, it's that we're learning some new technology and how to use it more effectively, not only financially for the clients, because your attorney may want to request actually a remote hearing to save money, and that is always the big question: is how do we get through this efficiently, and how do we get through it, and saving as much as we can and economically, and so it's equally important. So thanks, Melissa. As we approach our first break, don't forget, if you want to or have a question and you want to ask it live, submit that via the Q&A right now. If you'd rather just have me read your question, you could submit that via the chat box, and we'll get to that in the second half. And as we roll out of this first break, we're coming back, talk a little bit about distance learning, talk about the summertime and custody and what guys should be doing. So we'll be right back after this first break.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell & Cordell. This is what we do.
All right, welcome back. We want to kind of go right back to you, Melissa, and talk a lot about distance learning. It's the two words that we've been so familiar with from around the country, and specifically there are states that have year-round schooling, so that creates more challenges as it relates to even custody and visitation. But maybe, I guess, Melissa, the question for you is, are there really opportunities for guys who are watching right now? Sometimes we look at distance learning as really a challenge for us and really a burden. I get it with younger kids who, we're not trained, educators. We don't know how to keep them focused. We not really don't know the particular subject matter. But are there opportunities for guys here to use distance learning to their advantage in their case?
Yeah, I think there really are. We hear constantly from opposing parties that dad isn't as involved, homework is missing, it's incomplete on dad's time, he doesn't take charge of the children's education. But in this environment, parents in general aren't really dropping off their kids and leaving them for teachers to do a lot of the teaching and then following up with the homework later. Especially if they have weekday parenting time, dads are also getting involved on the day-to-day distance learning and the homeschooling, and it's becoming a lot more intense and hands-on than ever before. So it's giving our clients a chance not only to be more in tune and to have that opportunity, but also to prove to the opposing party that they are or have always been just as in tune as that other party.
And I think it's as equally important we point out an opportunity for guys. We should point out that this could be, an issue for guys if they aren't seizing this opportunity and aren't being involved, because I can tell you, if I were on the other side, I would be jumping all over that evidence and using it against guys if they're not remaining involved, even if they're out of state, right? They should be, really communicating and trying to stay actively involved, even if, their spouse won't let them.
Yeah, absolutely. And honestly, it gives dads who are further away and more remote probably more opportunity to be involved where they normally wouldn't be. So work on those schedules, have those conversations with an attorney about whether or not that's an option for you to expand your summer parenting time, and then be able to be involved in those summer schedules and in those distance learning, even if your children are in school year round, or even if it's just making sure that everything is complete through the end of the year.
Yeah. And, summer's coming up. Rex, I'm going to go to you. And we've talked a lot about the last few weeks about pandemic provisions, things that we've never had to think about, including in judgments and decrees, and they're likely nowhere to be found in any existing order that guys can seek, as guidance. But as we approach the summer time, Rex, the question, I guess, in Indiana, are there guidelines in Indiana that help guys, or at least they have a kind of an understanding of what custody should look like in the summer or generally?
Yes, Scott, good question. And with that, so the Supreme Court of Indiana put out guidance that said the existing orders, if they have those, are still in effect. And so the COVID pandemic hasn't changed that. And then also they've expanded out the opportunity that without filing, but as long as the parties will enter into a written agreement, then that agreement could be enforceable in a later action. So if the parties can agree saying we're going to shift left or right or do anything like that, then they need to memorialize that and put it in writing with the other party's signatures. And then if they have issues moving forward, then that's enforceable in court, even though it wasn't filed in an actual order from the court itself. So we are seeing different things like that, but the summer schedule should stay the same, and they actually put out guidance. Indiana, typically, you split the summer equally, and so people are saying, well, has it modified since they haven't went back to school? And one of the things that they put out is that you would go back to the original calendar that the school system put out at the beginning of the 2019-2020 for guidance. So you look at that and see when summer break starts and when ideally it would end without it coming to any other agreements or being able to file an emergency matter.
That's a huge point, just, not really Indiana specific, albeit it's helpful because it helps guys understand that there may be courts, and I know there are, and I want to say North Carolina had some guidance out there, and there are other states that particularly said that COVID isn't an excuse about not following decrees and orders, and I think that's important. So what should they be doing right now as they approach summer? Maybe there's some questions. You talked about getting something in writing, so should they be reaching out and communicating in writing to try to reach that agreement, and failing that, that's really good evidence for them?
Yeah, and again, I encourage all my clients to keep a calendar of when they're getting their children, when they're not, maybe when the other parent is missing time or even late for that matter. But yeah, absolutely, put a calendar together. Indiana, typically for the summer, the non-custodial parent actually provides or is supposed to provide to the custodial parent by April 1st their desires for the specific weeks that they want during the summer. So we're past that deadline. They should have already done that if they haven't, and that's in our Indiana Parenting Time Guidelines and that date specific. But if they haven't, as we're looking to hopefully co-parent and continue with some decent relationships, not all are that way, but yeah, absolutely. Open that communication channel open with the other party. And if they're not willing or agreeing, then absolutely, they need to contact their attorney to see what further steps could be taken.
It's a good point. We talk a little bit about the whole use of COVID. Laura, out in California, has California issued any guidance about using COVID as an excuse, to either deny custody or it can't be used in a motion to modify as the sole reason for filing or denying?
Yes, it has, Scott. There are several jurisdictions in California that have issued specific guidance about this exact issue. They've expressly stated that COVID-19 and the shelter-in-place orders, which we have here in California, are not to be used as a change in circumstance to modify your existing custody schedule. So I encourage all of my clients to look to their existing agreements. If they need to make some changes based on exchange locations, if those were going to occur at the school, fall back on your summer schedule. Use that and try to stick to that to the best of your ability. If for one reason or another, a parent is attempting to withhold the child due to shelter in place, I don't think that the courts are going to look kindly on that. If there is a potential COVID exposure, which I have had with a few of my clients, this is only valid until that client has received a negative test, at which point makeup time should be issued.
So, by and of itself, guys get confused. They're thinking, well, I can't use COVID, but it's the resulting action because of COVID, right? Meaning if mom denies them custody, simply saying it's too unsafe. There's no positive COVID-19, test. There's no other really good reason. We've talked a lot about nursing and, the first responders issues out in Florida. It just seems that judges are saying, look, just like solicitors in the UK, we did this. We talked to them a couple of weeks ago that the UK issued a statement and guidance that said COVID-19 is not an excuse to not follow an order, period. And so, I assume guys should be thinking about filing contempts or emergency motions if they're not seeing their kids unrelated to COVID-19 exposure?
Absolutely. If for whatever reason your ex or your current spouse is withholding your child from you, that needs to be documented and well documented by you. You can do your best to work with the person directly. I always recommend trying to negotiate a solution between the parties. First, in California, there's always mandatory mediation for any custody issue, and we're starting to see in some jurisdictions that those services are now being offered remotely.
Yeah.
So certainly if you can't reach an agreement, reach out to your attorney quickly so that we can resolve the issue.
So with this reopening in terms of every state and every county all coming up with different policies, Megan, I want to look to you out in Nebraska, and we want to talk a little bit about what it means for guys that are either thinking about a divorce or thinking about a modification or need to come back to court. But first, what's going on in Nebraska? What's happening with the court system? You know, I think I've read some things that they really never shut down like some other states, but what's happening in Nebraska?
Yeah, everything in Nebraska is, like everyone else has said, it's all county by county. And then within those counties, it's kind of judge by judge as well. The issues with interstate travel have been something that I've been personally dealing with on a case or two, and trying to figure out what those things mean. I wish I had answers as to exactly what would happen, but it's still kind of in progress, because it's not just, you know, can the judge have the child come back or go to the other state? But really, we're talking about re-entry plans. Who can quarantine? You know, when a child crosses state lines, what do we need to do to make sure that child is safe? And so there's a lot of moving parts to it that are still kind of in progress, because, you know, like everyone talked about earlier, the parties have never done this, the attorneys have never done this, and our judges have never had to deal with this either.
You know, it's hard to forecast or prognosticate, but do you see some of these changes? Do you think they're going to be more permanent in nature, the use of this technology? We've talked a little bit about it in our first part. Do you think that they're going to be more permanent?
I have heard from some of our court systems that they are actually really open to the idea of having especially shorter hearings be done telephonically, where otherwise we wouldn't be allowed to, or to be done virtually by Zoom or WebEx, because there's a lot of benefit and efficiency rather than having, you know, 20 attorneys all sitting there and waiting their turn. It's hop on for your hearing, hop off. And so I think that some of the courts are going to be open to that. I'm actually really excited to see how that can really benefit our clients here in Nebraska.
Yeah. Hey, Nick, down in Georgia, you know, for weeks and weeks, guys have been frustrated dealing with COVID. We just talked about it a minute ago about using COVID-19 as an excuse. They really want to know, you know, we talk a lot about the reopening. We talk about closing. What can guys do? Let's just focus on Georgia for a moment. What can guys do in Georgia to enforce their custody rights? They're in a judgment of divorce right now. What can they do in Georgia?
Sure. Well, as I said before, electronic filing has been ongoing, so you don't have to wait to file a motion for enforcement of an existing custody order. And, you know, as opposed to the judicial emergency order, which talks about what kind of hearings and proceedings can take place, we look to the executive order of the state, the shelter-in-place order, to see, to make sure that those exchanges can occur. And like in many states that I've heard, Georgia is saying that, yes, parenting time exchanges should still be occurring. And so if they don't, you still have that right to file that motion for contempt. Now, you're going to have to deal with your particular court to see how quickly you can get into court on that particular issue. I will say the hearing I had earlier yesterday actually we posed it as an emergency hearing, and I drafted a motion and went into detail as to the violations that this particular mother had done to my client. And we were able to convince the court in that case that this was an emergency. And in fact, we had it as part of the modification action. And we were able to win custody virtually yesterday on an emergency basis for our client. So it does happen. And I think the main thing, though, is if you have an issue, you've got to talk to an attorney and see what your options are. And then, you know, do realize there may be restrictions. You may not be able to go as fast as you'd like, but we're going to do, you know, as best as we can to help you get into court, or to otherwise, you know, help presume that parenting exchange to occur.
Yeah, and I think that was one of the 5 mistakes we talked about a few weeks back, is inaction, doing nothing, making some assumptions that just because there are either restrictions in place, the courts aren't taking filings, that you should just wait it out. And I think it really should have been the number one mistake, you know, guys make when facing COVID-19, whether you're thinking about a divorce or you're post-divorce, is, as you suggest, get with a lawyer. It's the best 30 to 60 minutes, you know, of your time that you'll ever use. And it gets even more complicated when we talk about enforcement of custody when you have guys in 2 states. or a guy in one state and a mom in another. I mean, it's just, it's a really, difficult situation that really needs to be analyzed. But again, waiting isn't going to solve the problem. And so, Christopher, I want to talk to you down in Arizona. Give guys kind of an idea of what's going on in the court system there. And I want to talk a little bit about a little bit more through in terms of enforcement of rights.
Sure. So here in Arizona, like my colleagues, the Supreme Court has allowed each county to determine how they're going to handle cases coming in or filings. For the most part in Arizona, especially here in Maricopa County, e-filing has been around for years. What we've seen now is some of the outlying counties have now also allowed us to e-file hearings. So here in Arizona, we counsel our clients not to wait because we can still file. We can get them in on the docket. A lot of cases that are non-emergent are being continued out, sometimes several months, but emergency hearings, at least for the time being, are being conducted in person. And other hearings have been scheduled virtually as well. So there's no reason for guys to delay. If they're having an issue, I would agree with my colleagues, consult an attorney, talk it out. There's certainly more than one way to resolve issues between parties. And, we can talk through all those options, and the client and the attorney together can determine what's the best course of action.
Yeah. When I started practice 27 years ago, it would not be unusual for a case to go 2 years or more. And typically the judges were taking cases in the order in which they were filed, meaning that I'm going to get to the oldest ones first, and which means, as you suggest, let's get on file right now. It'll give you the best chance, if we can't resolve it before a hearing, to get in line to have a hearing. And so what can guys do? Should they be doing discovery, informal mediation right now if they're already filed, just to try to get ready so that when things are either going to be open, you can have in-person hearings, that the guys are ready to go? Should they be doing all those things?
Absolutely, Scott. Keep documentation, like my colleagues have said. Keep a journal, keep a calendar, get those text messages together, get those emails, take those notes of what's happening so that when we are ready to go, we hit the ground running. We've ready, and we can move very quickly at that point.
Yeah. Well, we want to get to our second half, where if you have a question, now go ahead and you want to read it live and have it answered by our panel, submit that right now via the Q&A. If you have any other questions you want me to read and have our panel address, you can submit that via chat. And we're going to get to that lightning round, the final portion of our virtual town hall, right after this quick break.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
All right, now welcome back. So let's get to some of the questions that we have. We have the first one I'm going to send to you, Nick, in Georgia. It comes from John in Georgia.
Hi, thank you for taking my question. Do I still have to provide alimony to my ex during all of this? I work in the events industry and have been furloughed. She's been able to keep her job. Do you have any advice for my next steps?
So John, Nick just really wants to know whether he is required to continue to pay alimony, what we call spousal support or maintenance in some parts of the country. Been furloughed. It really is kind of like every other guy, the 10 million guys out there that are trying to figure out how do they maintain their bills and what's priority and should they be paying alimony?
Sure, great question, John. Thank you for that. Now, the executive order here in Georgia makes clear that none of your court-ordered obligations are cut short or suspended due to the shelter-in-place orders. Unfortunately, you don't necessarily have an immediate way to get relief just based upon the state of things with COVID-19. However, I would certainly strongly suggest that you talk with an attorney here in Georgia and talk with them about your options. There is a statutory modification that you can potentially pursue, whereby you can file a new action with the court asking that the court consider your new financial circumstances and perhaps decreasing or getting rid of your alimony obligation altogether, depending on your particular circumstances. The other thing is it depends on how the alimony provision was drafted into your divorce decree as well. So I can't really specifically tell you what you can do right now, but I can say have a consultation with an attorney. Let's see if we can figure out your best course of action, and hopefully you'd be able to go for a modification at least.
Yeah, agreed. I mean, there are so many issues that come up, especially with furloughed and decreased income, that your attorney or any attorney can really put together a strategy. Again, we've talked about this before, that one of the most important things is paying nothing is not an option. It's about prioritizing things, doing enough to keep in the good graces of the court, but also being able to make sure you support yourself. And so seeking out a consultation is really important. So Megan, let me turn to you with a question from Dan, if we can do that one, if Dan's got that one.
Hi, thanks for listening to my question. I live in Missouri and my ex is in Illinois. I'm supposed to have my child for the month of June and August, but now my ex is saying it'll only be weekends because she's weary of any travel and says she needs to have our kid to homeschool her if the school is still remote in August. Is there anything I can do to explain that's not fair?
So Megan, it really is Dan in Missouri is entitled to some custody in June and August, but mom is saying not going to happen for a number of reasons. Let's blame COVID, let's blame homeschooling. What can Dan do to try to enforce the rights that are in a decree that give him June and August?
Yeah, that's a great question, Dan. So one of the things that you want to look at is obviously getting a consultation with an attorney to see about your ability to enforce those rights ahead of time, or whether there has to be an actual violation first. I know here in Nebraska, we do have different things that we can do depending on whether that has already been withheld or whether there's a chance it might be withheld. And so you would want to talk to an attorney in the state where your order is out of in order to get a little bit more information about exactly what your best course of action is. But you definitely want to document any information that you do have, any communication, and take that to speak with an attorney about that specifically.
Great. Let me go to Patrick's question in, looks like Maryland. I'm going to turn to Melissa up in Minnesota. Patrick asks, can we get makeup time for visits missed during quarantine? So Melissa, that's what Pat wants to know.
That's a great question. In Minnesota specifically, yes, that is an option. If you're asking the court to enforce a court order for the parenting time that you have missed, we are asking the court to order compensatory time or makeup time for those missed visits. The other thing too that we typically talk to clients about is what are the circumstances around that? If it's withholding specifically due to COVID and a real denial of parenting time, it may also spark attorney's fees. We may be able to ask the court to award you fees for having to bring that enforcement action to the court altogether.
Yeah. All right, let me go to Laura in California. Michael has a question. Michael says his wife experienced a psychotic breakdown that required hospitalization 3 years ago with a diagnosis of being bipolar. Michael was unaware of the mental illness, and when she required hospitalization, she didn't give him the legal right to know about the condition at all. Now they're heading to divorce, and Michael wants to know if he's able to disclose her medical diagnosis to his legal representation or to the court. So Laura, I guess Michael just wants to know what he can tell his lawyer.
Sure. Michael, you can tell your lawyer anything. You should tell your lawyer everything. And it sounds like her medical condition could be at issue as to whether or not she could be a safe or appropriate parent, when you are separated. So this is something that you are going to need to look into. It is something that is valid and appropriate to bring both to your attorney's attention and to the attention of the court.
Great. Yeah, and I think it's important. I've always said in one of the live web or seminars that I do in person, one of the mistakes is I call doctor versus lawyer, and that is, many people who go see a doctor, they share everything, and they share things that are irrelevant, the smallest of details. But when you go to your lawyer, you're not sharing everything for whatever reason, and you either are afraid to share it for legal purposes, you're afraid to share it because it's embarrassing. So as Laura suggests, anything and everything is important to share. There's an attorney-client relationship and confidentiality that attaches. And then, in that conversation, you can talk about what can and can't be disclosed in court and used in your case. So I think that's important. Let me go back to Megan real quickly, because we got one MSI from Nebraska has a question. Megan, I've been unemployed for almost a year, located in Wayne, Nebraska, current on child support. They want to go back to court to get the child support reduced. They've gone to the DHHS website and following the guidelines. Two-part question: what else should they be doing? And two, being in Wayne, is this something that you can handle out of Lincoln, or is it something that someone should go to the Omaha office for?
Yeah, that's a great question. Wayne would likely be assigned to the Lincoln office, either myself or the other attorney in my office, whose name is Chris. And that's something that we'd likely be the ones appointed for that. As far as what you need to do when we look at child support modifications, you want to have a lot of documentation about not just the fact of the unemployment, but the reasons surrounding it. And so you want to start gathering up any information regarding searches that you've done, attempts that you've made. The other thing to note is that for our child support, sometimes there can be some difficulties in being able to reduce it just based on, a change in employment. What you want to be in line with the guidelines as far as that. But also in January of this year, they did change the child support guidelines, and that by itself is a reason to be able to go in. And so you might be able to look at just the guideline change themselves from January to be able to open up a case on that and attempt to modify your child support.
Yeah. So let me go to an anonymous question. I'm going to turn it to Rex in Indiana. Rex, the question is, does the custodial parent have any option for making the non-custodial parent participate in distance learning for the children? My ex is the non-custodial parent and refuses to help with the distance learning, even though we really need the help. They say I'm still working full-time from home and providing care for the child full-time, as well as helping with the distance learning. I'm trying to keep up, but it's been difficult, and I'm afraid that the non-custodial parent will use it against me later if I do not keep up with the distance learning and the school curriculum. So what can this anonymous question, and what can they do in order to force the non-custodial parent to participate, and could it be used against them if the child struggles?
Well, that's a great question. I think it offers a lot of different answers and actually an opportunity to look at all the resources that are available. I looked at this actual piece before because I had a similar instance. And so a lot of resources right now are being offered via online tutoring for, elementary, middle school, and even high schoolers. That's free now versus it wasn't before. So and those are teachers as well as, obviously tutors to assist those individuals and those children with, accomplishing those distant learning classes. The enforceability of trying to get the other parent, certainly that's a little harder bridge to gap. The encouragement, hey, I need your help here, etc. Obviously, documenting that, whether it's in text, email, our family wizard, whatever resource they're using to communicate, and definitely showing the unwillingness from the non-custodial parent is going to help as a semi-defense if it was needed when they go to court.
Yeah. Christopher, I've got a question out of New Mexico for you, Christopher. Anthony says, I just retained a lawyer. What should Anthony be preparing to list and submit to his attorney on the property question and assets section so that Anthony is as thorough as possible and helps the meeting be efficient and productive?
So my first answer would be everything. You want to disclose everything to your attorney. However, here in Arizona, when it comes to property, you want to start gathering statements for every accounts that you have, deeds and bills of sale for any kind of real property, Certainly loan statements for credit cards, automobiles, any insurance policies. Essentially, your lawyer is going to want to see a snapshot of your financial life, things that were purchased during the marriage, things that were possibly sold during the marriage, because those are going to be relevant to several issues in your case. If you have children, it will be relevant to child support. If your ex is going to be asking for alimony or spousal maintenance, as we call it here in Arizona, those are certainly going to be important. So you want to keep good records. Of course, I forgot to mention, obviously, pay stubs, W-2s, tax returns. Those are the three probably most important that your attorney is going to ask you. But when you go in with your meeting with your new attorney as well, they're going to talk to you about the specific facts of your case, the specific property that you own, and be able to give you a detailed list of exactly what your attorney is going to need to be able to defend you effectively.
Yeah, it's a huge thing. I think I just addressed this in one of the daily podcasts, and particularly when it deals with property, we're talking about the personal property. So there was a question by a gentleman one time said, you know, I want my guns, my jewelry, my coins, my stamps back. And she won't give them to me because she says they're hers now because the judgment says they belong to her. And you have to be really careful, Anthony. There's a provision in most decrees, it's this catch-all, that if it's not specifically delineated within the judgment about who gets it, then the person in possession of the property not set forth gets it. And so I tell guys, look, one of the mistakes guys make is not inventorying their personal property, especially the separate property they bring in. So if there are albums, jewelry, guns, ammunition, whatever it is, if you want it, list it on the statement of property and make sure your lawyer puts it in the judgment particularly, because you will never see it. I always started out in these webinars in person as you will find your things sold on eBay. You will find them given away on Facebook Marketplace, set on fire, left in the snow, left in the rain, whatever it is. If you didn't ask for it, it's gone. So, and as Christopher says, everything. And I mean down to the spoons and the forks, right? And then we can sort it out. So let me get to the next question as we're kind of getting close to the end of our time. I want to go to Melissa, because I think this you covered this a little bit, Melissa, up in Minnesota. But Andrew says, if your children are doing remote learning, but they are with the ex during the school week, what can the father do remotely to show evidence and help show the judge they are still involved in the children's remote learning?
That's a really good question. So first of all, I would say make sure you have access to what the children are doing. Make sure that you have the same access to get into their remote learning that the other parent has. And if not, then get that access so that you can keep track of what the children are doing. Then when they do come to you, you can say, hey, I saw that you did this today, or I saw that this is coming up in your week schedule. Let's talk about it. How was that project? You know, how can I help you do that project? Try to be proactive with the kids in terms of how you can help them and how you can support them during this time. Talk to them about how they're sitting at a computer doing it. Obviously, you know, this is hard on them too. So even just listening to that emotional part of it, even if it's not specifically related to the schoolwork itself. And then follow up. If you've seen that there are projects that they were supposed to do or assignments they were supposed to do, make sure that they've done them if you have the access that you should have to their remote learning. Or if they haven't, then follow up and say, well, why wasn't this completed, or how can I help you get this completed? And if you need to, communicate with your co-parent about how you get that done. That communication is really important right now too.
Yeah. So we got our last question. I'm going to turn to Laura in California, and hopefully I get the pronunciation of this person's name, Badan. Wants clarification on the comment I made about paying nothing as not an option in child support if you have no income to support yourself and are dependent on friends and family to support yourself. What are the consequences if you pay no spousal support or no child support due to a lack of employment? Then you've made all the efforts to file a change in circumstances. And so before, Laura, you get to it, I'll just kind of make a comment. I'm curious what you think, Laura. You know, in my experience, 27 years, what I've seen judges do, they want to see something. And I mean, I say literally, it could be $1, it could be $5, it could be $100. And this is why it's so important, you know, from a judge's perspective, their analysis is going to simply be that you're going to be able to find something to pay, whether it is a few bucks, but it's got to show a true, genuine, legitimate effort to make a payment. So you're going to go through all of your expenses with your attorney, and let's figure out ones we can put off if we can. We just have to find a way to do it and to show some good faith. And even if it puts you in a bind, if you're late and you're incurring late fees, I mean, that's the evidence you want to submit to the judge and say, look, I had to make a choice. Now I'm going into serious debt. I've got debt collectors calling me, but I'm making some payments. But Laura, I'll turn to you. We've got about 30 seconds.
Thanks, Scott. I agree with a lot, pretty much everything that you said. Making an effort in the view of the judge is going to be very important. The reason why we say that paying nothing is not an option is because your change in circumstances has not changed what the court has ordered you to do. So if you do fail to even make an effort, you'd be risking contempt or a large arrearage. Now, in California, at least, these requests for modification are retroactive. So if the hearing goes forward, the judge could retroactively modify your support to a lower amount, which would give you some relief. But you'd be taking that risk if you chose not to pay the full amount or when were unable to pay at all.
Yeah, it's a tough thing to swallow, but we want, our job is to put you in a position to minimize the negative effects. The judge is your jury, and representing guys is about appearance and presentation. And it's so important. You've already got a couple strikes against you. The last thing you need is to pile on something with a really bad choice. And so, again, I'm not saying it's absolute, but it's a conversation piece. So make sure you schedule that consult with an attorney. So that's all we have for today. Thank you for joining. Continue to tune into the daily podcast where we'll address your specific topics. Spend about 15 to 20 minutes. And also the questions you have once each week, we'll address those. We're certainly happy to consult with you from one of our offices around the country, including the UK. You can visit us at CordellCordell.com or 866-DADS-LAW. We can schedule a consultation in person where appropriate, telephone, or virtual. Thanks to Lexicon, a company handling law firms and service and technology firm. And again, until next time, have a good week.